Hello, this is a presentation brought to you by Family First Legal, presented by yours truly, Butrice Walker. Today's presentation will be on Maryland's limited divorce law. The first thing we're going to look at are the qualifications for a limited divorce in Maryland. You will need to have grounds and you will need to meet residency requirements. And we're going to go through each of these individually. So the first one we're going to look at are the grounds. Separation is one ground which you can get a limited divorce on. Separation does not have to be for a period of time or a set period of time. It has to be for a reasonable period of time, and that time will be whatever the court feels is reasonable at that point. So if a reasonable person would think that you all are separated, then generally you could file for a limited divorce. Separation does require still that for whatever period of time it is, that there has not been any cohabitation, no sexual intercourse, and that there is no hope of reconciliation at the point where you're filing for that limited divorce. The grounds of desertion, which are similar to those grounds which you would have seen in the absolute divorce presentation if you've watched that, require or is similar to what has been called abandonment and require a duration of any reasonable time of where the spouse has deserted you or left you or caused you to leave them. And this desertion must be unjustified, deliberate, and with an intent to desert, which lasts for a reasonable period of time, meaning that whatever time period you're saying that the desertion lasted, that it's been also during that time that your spouse has had the intent to desert you during that entire amount of time, whatever that time period is, whether it's 2 days or 2 weeks or 3 months. And desertion can be actual or constructive. Actual desertion has to do with your spouse actually leaving you and deserting you for a period of time. Constructive is more like when your spouse forces you to leave because of their behavior. And that could be some of the behaviors that I have listed here, such as cruelty, asking for or demanding abnormal sexual behaviors from you, refusing to move out from their parents when there's no viable or good reason for them to continue living with their parents. So you can see the other potential reasons there, and there may be others. And then there's another ground is cruelty and excessively vicious conduct. Now, this can be against you or against your child, and it usually must be continuous for this ground to work in a limited divorce. However, one act may be enough, and if you can get that here, generally that one act will actually be enough for you to get an absolute divorce. So you can use this for a limited divorce, but if you have that one serious act or continuous act, you may want to consider getting an absolute divorce if that's what you're desiring. There are purposes for which you get a limited divorce and other reasons why a person may want an absolute divorce. But those cruelty and excessively vicious grounds are going to be very similar in both cases. So you could use those grounds to either get an absolute divorce or a limited divorce. Some defenses to your grounds for limited divorce would be if there was desertion, a claim of desertion, whether actual or constructive, consent could be a defense. So if your spouse leaves you and you all have agreed to that spouse leaving, there's agreement that you all will separate, that wouldn't be considered desertion because that would be consent, that you've given consent for your spouse to leave. And vice versa, if you leave and your spouse and you have made an agreement that you're going to leave, that would be consent also. So desertion would not be a ground for your limited divorce. Cruelty can be negated if you have been a provocateur of the cruel acts. So you engaged in cruel acts towards your spouse, which in turn caused your spouse to become cruel towards you. That may bar you from using cruelty as a grounds for a limited divorce. Residency requirements for a limited divorce are similar to those of an absolute divorce in that one party must reside in Maryland for at least 6 months prior to filing for that limited divorce. That party must have an intent to remain in Maryland. And this has been a general overview of the limited divorce. There are some other considerations that you may want to think about In this situation, different from an absolute divorce, a name change will not be granted during a limited divorce because your marriage is not terminated, and therefore that right to change your name back to a premarital name has not accrued in a limited divorce. Property and alimony. Property is going to be differently distributed in a limited divorce. In this case, a property will not be divided at all. It will just simply be looked at as who gets use or possession. While in an absolute divorce, very differently from this, it will actually be separated. So here in a limited divorce, you'll need to know that your property won't be separated. So if you're looking to have property separated or split at that time, then you're going to need to be aware that use and possession is the best the court is going to grant one party the use and possession of personal or real property. Alimony can be based on circumstances granted for a duration of time that is temporary in nature because this is a limited divorce. Usually you're not, or usually or not at all, will you ever be able to get a long-term or permanent order of alimony in a limited divorce. The court must have personal jurisdiction over the party who will be paying alimony in order to award an alimony settlement here. Alimony will generally be modifiable in a limited divorce because it's only meant to be for a limited period of time. If you have children, then the parenting plan and child support section of this learning module will apply to you, and you will be able to decide who will have physical custody, who will have visitation, who will have the ability to make decisions, and some other considerations here are whether one of you might need tie-breaking authority in certain types of decisions. Maybe one of you are better making decisions about educational needs and the other is better at making decisions about healthcare needs. So that would be a reason why one party would have tie-breaking authority. Tie-breaking authority works in such a way that if both parties are in disagreement about what should happen, the party with tie-breaking authority may, after consultation with the other party, make the final decision about what will actually happen for that child as it relates to what the child needs, whether it's educational needs, religious needs, medical health needs. And then you will want to think about holiday and school schedules. A lot of times people are making schedules for children or visitation, but haven't taken into account that extended holidays may exist and school schedules may have an impact on those visitation schedules. And then child support can be allotted in a limited divorce, similar to the absolute divorce. Both parties are responsible for paying child support, so the court will use a calculator to determine, based on both incomes, how much the primary custodian of the child or children will need in order to maintain the status quo for the child. And that's pretty much it for that limited divorce. This is a good overview for you. It should give you an idea as to whether this is a best fit for you. If you do have additional questions, do check out our website at www.fflmd.com or contact us using our contact page on that website. Thank you.